responsibilities include overseeing 6 regional mediation centers and granting us funding, all those good things that come along with being the director. She also furthers mediation and resources in mediation and APR. Since 1992, she has mediated and facilitated issues ranging from family and child welfare matters to public policy issues. And for 15 years, she served as director of one of the mediation centers in Walthall. She was the founding director of the Nebraska Justice Center. In 1999, she helped pilot the family competency program with the Department of Health and Human Services and Children, Families, and the Law in Nebraska. Since 2007, Debra has been a member of the National Child Welfare Collaborative Decision-Making Network affiliated with the Association of Family and Conciliation Courts. Our next presenter is Debra Blue. She is a program director at the Concord Center in Omaha. She has been there for 9 years, and from February to August of this year, she served as interim director of that program up there. As her duties, she coordinates pre-hearing conferences, family mediation centers, victim offender mediation programs, and the Sargent County Small Claims Program. Our next presenter is Romney Olson. She is with the Lincoln Center in Lincoln. She's the Director of Family Mediation Services, doing work with FGCs, pre-hearing conferences, mediation facilitations, and she's been doing that for 6 years. Her background is planning for a living. She has been a preschool teacher, daycare, and she's done classes at UNL and SEC. During this session, you are going to learn about Nebraska's experience with facilitation of the termination of parental rights. There will be a discussion on why facilitate TRPs. It's much easier than to say termination of parental rights. That's a long. What are the goals of the settlement conference? How to address civil liberty, confidentiality, and privilege. The timing, optimum timing, and referral process for TPR facilitation, and some actual case studies will be cited. Please welcome our presenters.
Thank you, Judy. And I think we have to use the microphone as much as possible because these sessions are being recorded, and I think that'll help the recording. Again, welcome. I'm really pleased to be here along with our colleagues, and I want to thank Kelly Hopman for her leadership in working on this conference and making ADR as one of the tracks. And so she worked with us early on to figure out what breakout sessions might be useful for judges, child welfare providers, lawyers, CASAs, and others who are in the child welfare system. Facilitation of termination of parental rights, when I first heard about it, kind of sent civil liberties waves through my, up the back of my neck, because I used to be a parent's attorney as well as a guardian ad litem in juvenile cases in Lancaster County way back when. And we all know that people's parental rights is a key civil liberty. So as a mediator, one of my early questions was, how can you have a mediation in which the assumption that each party at the table has equal bargaining power, how can you mediate a termination issue? Because clearly the parents won't have equal bargaining power at that stage. And hence why we're calling this not mediation, but facilitation. It's a facilitated dialogue on the questions that lead up to termination of parental rights. And Romney and Debra and I will go more into this as we go forward, yet I want to say from the outset that we need to be very alert to, we're working what I would always say is a mediation trainer, interest-based process, which is cooperative, collaborative by its very nature in a rights-based system. We have the civil rights of parents, the best interest of children at stake, the interest of the county attorney and the state in the safety and welfare of children. So because we are trainers and we love to do interactive things, we have a case scenario that we're going to start our discussion out with. And I'd like for you, we're going to come around and give you copies of this case scenario. We're going to ask you to read it. And in your small group, each one of you think from a certain role. There's a role of a judge, the role of a parent's attorney, the role of a guardian ad litem, of a child welfare person, of a parent, of a child, a grandparent, and we'd like for you in your small group to briefly figure out who's going to think from each one of those 6 or 7 roles. Read the scenario, and then take 5 to 8 minutes to answer the questions. Is this scenario appropriate for a facilitated meeting for termination of parental rights? If so, what kind of process might we use? Who should be at the table? What issues that might you discuss? Who might refer it? And we decided to start out with this because this is a pretty sophisticated group in this room. You may not have all been involved in a mediation or facilitation, but I'm guessing most of you are familiar enough to know what's up and what's down. And likely you'll have someone who's done this in your small group. So just pull your chairs around with about 5 to 7 in a group, if you would, please. And we'll come around and hand out your scenarios.
I know it. We need a few more up here. Yeah, we can use a couple more tables.
We're all from the dentist. We all know each
When I work with
other. From the what?
The child advocacy center.
They get a lot of rain.
No. I'm Mimi. Jordan. Courtney.
I was going to be a child. I've been on
That was a start.
Yeah.
Hello, hello.
Yeah, hold it back here. We need to pair a pair of glasses. I don't want to touch me.
We haven't got one yet. We need to solve this.
We have 0.
You don't want
You make it up.
I'll make it up.
Thank you. We have you're already sharing.
Who's a good one?
After the night. Okay, Sam, you kind of. 2 children, Charlie.
Share.
6 months.
Take notes. You could just go in order. Judge. She's like, no. Judge. Yeah. I don't know if I can do that. Parents attorney. Be the deadbeat parent. And you're the grandparent. Okay. Judge, which APR process should we use? Well, what if we know so much about different?
We spread this out a little bit so you know.
I know, I was like, there's different ones. I thought it was just.
That's the
We're doing a little group exercise.
You want to join this group?
You're doing who?
We're doing a little group exercise.
Thank you. Hey.
Good morning. Hi.
Hi, how are you?
Good. How are you? It's nice to meet you.
What's your name until I get it down?
Oh, it's Jordan Bowler. Bowler. B-O-L-E-R. Miss, what's your name?
Good to meet you.
Good to meet you as well. Okay, so we just assigned roles, and so she's the judge.
Take some lessons.
That's how it's done.
I have milk for you. Watching that phone.
What? We didn't assign the last one. Okay, you get to be the kids. Assign all these roles except the kids. The kids. I'm the deadbeat parent. Deadbeat parent. Okay, I think the first thing that should be facilitated is probably a relationship between the parents and the grandparents. Should there be some kind of animosity going on there? Well, you could discuss with the parents. Or the two aren't getting along. I'm a county attorney. Yeah. I'm just kidding. Take that back. Great to see you guys.
I'm the guardian of the
You don't think it's in the best interest of your mom and dad. I suppose as in the role of a parent, and just angry at the grandma. It'd be nice for somebody that explains to me that it wasn't her decision.
Well, you can't have a conditional. You can't have a conditional.
Maybe that would help mend our relationship.
How do you go back on the
If she doesn't want me to,
contact agreement?
I was going to say the same thing on the school. There's a family relationship here that goes because of her, and they're all protected to their replacement, but they're still and I don't want to. I think it facilitates convenience and help to keep it intact. family relationship, no matter what happens. If that's possible.
I'm a long around here.
About 5 more minutes.
Yeah.
Find someone who will be around.
It makes it seem like it's yeah. You know, the parents are making it seem like they're the ones who are more here showing the love of the grandparents. I think maybe they're trying to so I'd like to be as a parent, I guess if I'm in the role of a parent, I'm wondering if I were to relinquish, and I don't have really a right to visitation, I think, right? But maybe a guardianship, you have a right to
Start over. If they are probably going to
Life in prison. Which one?
TPR thing yesterday where they were talking about
I'm a skeptic.
Lancaster against parents on new TPR filings because we don't predict that this company will have to get your opinion on that because
What's the end result? Are they hoping to
so if a parent has relinquished a previous child, they'll do that in addition to TPR on a new child.
if you could just kind of.
Can we get?
We gotta move on. Sorry. Yeah, I apologize. We have to kind of keep moving on. We only have an hour here. And this is just enough, hopefully, to whet your interest. I'd like to hear a couple of comments, observations, some of your assessments in your group. So I'd like maybe 4 or 5 volunteers just to review what insights you came up with or questions you still have. Yes?
I thought the parents and grandparents were more reasonable than the rest of us.
What does that mean?
They were more willing to have a facilitated discussion, even though everybody had the same circumstances. But I think at least I was in the role of guardian ad litem, and I was protecting the children and not wanting necessarily to talk about it. And so I think maybe people's roles are so set in a more adversarial kind of way that it's hard to.
As Chris was describing, more focused on their traditional role in the adversarial model and feeling a little fear or concern or wariness about facilitating discussion. And that's a helpful insight about, will people necessarily voluntarily select ADR in today in our state if they're thinking from a more traditional professional role perspective, and that kind of gets into the question of who refers these cases, and if the cases are referred, will the participants all join in? And in some models, the judges will issue an order saying, I want all of these parties to participate in a facilitated TPR. So that's one solution to that traditional way of thinking. Other comments? Yes, up here.
And I'll preface my remarks by saying we have disagreement.
Good.
In terms
Yeah,
of the
disagreement.
process
Yes.
and what roles people should play, even whether the TPR was time filed and the judge had to leave. I said I was the child. I was the children. I was the children. And I'll talk about what I wanted to do. The other guys can talk about what they wanted. What I wanted to see was an interest-based mediation with only the parents and the adopted grandparents. Because my read of the fact pattern was they had a lot of history between them. And as children, I want to be able to have stability with my grandparents, but I want to see my parents as well. And I don't think a facilitation with a lot of non-family members is where you're going to have the parents and the grandparents be able to get to the nitty-gritty of what their family issues are. But that was what I wanted, but I think I voted. I think I had the grandparent.
Well, I was mom's attorney, and I guess my perspective was that it really depends on the perspective of the parent. I mean, if the mom is sort of accepting of these facts that TPR is inevitable, then going through with a facilitation specifically, to look at visitation, contact in the future, post-TPR would probably be beneficial given that we have some history between the parents and the grandparents. But obviously, if the mother is not hasn't come to that conclusion, then I would probably be more adopting that kind of variable and not want to participate in that. The other sort of question I have is, we have this dispute resolution. What binding effect does the outcome of any of this have once the children are adopted by the grandparents? I mean, that would be, I guess, a concern that might also cause them to adopt a more positive perspective and maybe not be able to go forward, particularly if this maturity. But I think if mom's in a position where she's acknowledged that she's not going to, or she's not capable of parenting, then it's probably a good idea to actually suggest that. And I think there was some.
Did everyone hear these comments? Those are really important system level questions as well as what we would call the micro level. What does the parent's attorney do in terms of what the parent is wanting and looking at? And we also heard from the child and what the child would like. The child just wants everyone to get along. They want mom and dad and grandparents to get along. And I think the analysis of I'm parent's attorney is right on target. All of that kind of analysis needs to happen to determine whether this is an appropriate case for facilitation. And of course, Nebraska doesn't have, at least right now, doesn't have an open adoption law, and so contracts or agreements for post-contact involvement are as good as the words that come out of the mouth. One more comment. Another group would like to give your observation, questions.
Yes, sir. We focused a lot, I think, about the information that wasn't in there, and it was kind of tough to fill this through. And there was a general consensus that everybody would get together. We thought maybe at a family group conference, and at that time, I think there was a consensus that there was issues between the two parents, and if this was a kind of a last chance prior to a termination hearing that we could try to decide, and I think there was issues between the two of them, which could parent and whether reasonable efforts have really been made with this family to deal with all the issues. Parents, one of the dad's attorneys said, well, they told me to go to therapy and gave me some drugs and that's it. My mom was saying, well, maybe I can do this on my own. What kind of issues do we have there? What are the concerns that they have? Guardians' lives, of course, and helping for the safety of the children. And I think those are just some of the issues. We weren't certain if it was right yet because we didn't know what the history of all the services that were there. I think that was the issue.
Yeah, actually, I'd like to respond to I like that idea about just the children and the grandparents, but I do question that this is not a therapy session at this time. This is information that I'm trying to assess for if I identify. In fact, I'd also like to see other family members involved who might be other support members. Maybe come up with a solution. And that's the purpose I would see this.
So having other family members perhaps recruited to bring in, see what kind of
Right,
resources.
it's just, we're here for solutions.
Solutions.
Not so much as therapy.
Okay, great, solution oriented, yes.
A question, comment. When I look at, as a parent's attorney, looking at this and whether my client participates, and go over co-counsel over here, what's the benefit of my client in participating in this? What's in it for them? And that, as parent's attorney in this kind of situation with our laws, I'm like, why would we do this?
Yeah, why would we do this? Well, that is part of the question, and there are reasons why some parents' attorneys have actually gone forward and done this. And it's a healthy discussion with the parent. And I'm going to have Debra, this is more of raising questions. We're going to put forward some principles and concepts for all of us to think about as we go forward in the state of Nebraska, because on an ad hoc base there have been facilitations of TPR cases as we speak. And we're going to be starting a small pilot project. Health and Human Services contacted me last week with a wonderful opportunity to pilot a few facilitated TPR cases across the state in the next 18 months. I want to thank HHS for this opportunity. We're going to be piloting in the 3 separate juvenile district courts, as well as at least 4 rural courts across the state. So this dialogue with all the stakeholders in each of these pilot areas, that's the starting place. Let's sit down and have a dialogue ahead of time from a system perspective, so that we know when we go into it, we know what we're heading for. I'd like Debra Blue to come up, and this was an actual case that Concord Center in Omaha facilitated, and so Deborah's going to kind of give you the rest of the story.
The parents and grandparents had been to therapy together to try and work on their relationship, because by the time we got the case, their relationship had deteriorated and there was no communication. The therapy sessions didn't work, so they were hoping, actually several months before we received the referral, when the TPR was filed, we had tried to schedule a mediation between just the parents and grandparents with no attorneys present, just to talk about a communication plan, to have more positive communication for the benefit of the children, because of course everybody involved in children's lives, if they're bad-mouthing and not getting along, that's detrimental to the children's well-being. And that just wasn't possible. We couldn't get them to the table for a productive meeting. So when TPR was filed, we did get the referral again, and with the attorneys and parents and grandparents, they all met. And at this point, it was determined that the parents could not safely provide a stable home for the children due to mother's health issues and medication she was on. She was not always aware enough to be able to parent the children when dad was at work, etc. So it was a very emotional session, but everybody got together and came up with a plan for the grandparents to adopt the children and continued contact to bring those parents back into the family on a consistent and positive level. The parents were, by this time, willing to do that also, wanted that continued contact with their children, and saw that even though it was painful to them, that would be better for their children to have that stable environment. I think the thing that came out of it was that the parents and grandparents did start a foundation for a better relationship, to start mending their relationship together. And the real focus that they were all able to gather around the table with is what was best for the kids. And that really joined the parents and grandparents at the table at that time, was their love of those children. And being able to sit face to face and have that conversation was the turning point in that case.
Who all was involved at the table?
The parents' attorney, each of the biological parents, and who are still living together. The grandparents, case manager, probably, and a supervisor for Health and Human Services, guardian ad litem, and I think that's about it. No, we have never had a county attorney come to a mediation or a family group conference. Typically considered a conflict of interest.
What was the contact agreement?
That they were starting off with just that the grandparents would be the permanent home for the children, and that they would start with, they were going to have the bio parents come for holidays and just start introducing them into family events as they had been doing for years, you know, as the children were in and out of grandparents' home.
Did you discuss guardianship as well?
I think that was part of the conversation. The children are quite young, and I know it was a combination of everybody having complete information on the differences between guardianship, adoption, and all of those options. And I can't remember exactly which one they ended up finalizing, but I did follow the court system.
How old were the parents?
The grandparents, I think, were probably in their late 40s. They were young parents.
This was an example of, when we talk about case type, it was a facilitated TPR. Facilitated meeting, the termination of parental rights. It wasn't a mediation, because again, the parents really didn't have equal bargaining power there. It was not a family group conference. Could have been. Could have brought in paternal grandparents, other aunts and uncles. That has actually been done as well. Part of what the mediation centers do when they get a referral is, you know, the best practice would be to do an analysis of the circumstances of each family and the children, and to determine what collaborative process would be helpful for the children to move the case forward. Yes.
When you began the facilitation, what was the premise? Or that is, here's what we are here to do.
What was the issue that brought us to the table?
The goal of the meeting is to discuss permanency for the children and also future contact and future relationships. That was just kind of.
So the presumption was parental rights are going to be terminated or relinquished. That's the conclusion.
Okay, brings up a lot of good questions, and in the time that we have remaining, I want to mention that on your flash drives that you have, this PowerPoint is in there. We also have attached to this, on your flash drive, a sample agreement to mediate, TPR case. We changed the word to facilitate. This is still kind of rolling out. We also have copies of Nebraska confidentiality statutes in terms of what's being said at these sessions and what's privileged, which these are privileged communications. And also in your materials on your flash drive, there's protocols for a permanency facilitation. So all of those kind of resources are available on the flash drive. Question was asked about goals, and it is to provide an opportunity for the bio parents, the foster adoptive parents, guardian ad litem, child welfare staff, others to address unique issues involved in termination. To look at the best interest and permanency for the child. And then to facilitate a dialogue with the people who are at the table. We're there to explore permanency options. Would voluntary relinquishment make sense? Would potential guardianship or adoption? What would happen if we have to go through a litigation for termination? What about further work toward reunification? In our discussions to prepare, I've heard that there's been at least one, if not more, of these facilitated conferences where it was determined, I think there was a new caseworker on the case, that there hadn't been enough reasonable efforts. So they withdrew the petition to terminate. And I don't know if Debra or Romney might talk about that a little bit later, but those are the focus points. I'm going to have to kind of keep turning back and forth because there's not a visible screen here. Termination of parental rights is a core civil liberty of the parents, and we know it's a critical legal stage. We know we need to look at the best interest and the permanency of the children. So we, as Jeff was pointing out earlier, we have some very critical parental rights that need to be addressed. So how do we, as a system, look at this as an option and recognize, for example, as a parent's attorney, as a guardian ad litem, as a county attorney, is this something that we think will work in this case? It really does need to be a case-by-case assessment. And we can help you as process people make that decision. Several states in the United States are doing facilitated TPR. When I did research for this breakout, I talked to people and got information from Arizona, New York, Illinois, Florida, and other states. There's a National Child Welfare Collaborative Practices Network that I'm a part of that is going to be putting together best practices on these uses. So I'm hopeful that just like we have the resource guidelines, we'll have more national guidelines along this way. What has been our experience? Judicial referral. Health and Human Services has referred these cases. We've had a historical partnership with HHS, and again, I'm glad to say that we're going to continue in that for the next about 18 months. And briefly talked about using an interest-based process and a rights-based system. There's going to continue to be bumps in the road on this. Just as I was kind of struck by all of the advances that the teams have been having in their local communities to improve child welfare practices and outcomes for children. It's bringing the teams together, those core stakeholders that are really helping to make differences. So why not use that same model for families and children? Have this more collaborative process to make better decisions. And it kind of also ties in with that whole idea of connection, connecting people with each other. The formal court process has its place, and it is necessary in our society, yet it doesn't really engender that kind of how do we make connections and how do we solve problems. What are some of the essential aspects? Again, just another way to look. We have to look at the legal aspects of termination of parental rights and relinquishment and adoption. We have to look at the child's best interests, their connections with their family, what kind of ties they've had with different family members, and what they haven't had. Your emotional, relational aspects of relatives with the children. And I'm going to turn this over now to Debra and Romney in terms of timing and referral issues.
I'm just going to go back a little bit to the child's best interest because I think that timing and referral, my experience is it has been that collaborative practices can be used throughout the life of a case. I've done expedited cases, I've done voluntary cases, I've done cases that involve talking about termination. I've done cases where it's likely that termination is going to happen. We need to get it out on the table and talk about it in front of, while people have attorneys present to protect their interests, but then can also have that private conversation in a family group conference with their family to say, you know, I'm still going to try. I'm not there yet. And those have been very fruitful because they've already had the conversation, and then later on, what we hear back is relinquishment is often the result. It usually isn't filing a termination. So the timing, from my point of view, is refer a case when you think an adversarial approach is not going to be in the children's best interests. And I think we've learned a lot from doing the pre-hearing facilitations that there are certainly cases that come before the courts who obviously have the final say about any agreement that we reach in a pre-hearing facilitation, whether that's an appropriate way to go forward. But there are some cases where parents have had their rights for other children terminated. It's unlikely, you know, they aren't at the first hearing. Those are cases where, you know, pre-hearing facilitation may be good to have all the attorneys and everybody sort of go forward on the same steps and be real clear about what the information is and how to go forward. But our primary purpose is to help the parents better understand what's necessary, have the children's interests brought to the forward. Because so often what we find is these parents are so enmeshed in their own difficulties that they forget what their kids really are going through and what they need. So I guess from my perspective, timing let us figure out what process might work. And you know, we also rely on all of you to give us information. We can't do this in a vacuum.
We have been providing service facilitations and pre-hearing conference as well as family group conferences, expedited family group conferences, and then facilitated all along through the life of a case. We've had a mediation just between parents on how they're going to behave in a family group conference. You know, what kind of communication plan are they going to have so they can sit and have a productive meeting at the family group conference. So we just really look at every case find out what the barriers are and the challenges that these families are facing, what the service providers, what the attorneys are running into that's causing barriers for these parents to be successful or to be able to move forward. And then we can figure out what process is going to best meet those needs to get over that bump. I think one of the most important things about having a facilitated meeting is that parents don't want to be, especially in these TPR cases, I've often found they don't want to be viewed as giving up their kids or allowing their kids to be taken or giving them away. I mediated a case with just the foster mother that wanted to adopt this gentleman's son who did not have the capacity to have a stable home for his son, and he knew that. And he sat down with that mom, and they just talked about their love and interest in that boy, and what their hopes were for the future. And to have those two people from such different backgrounds really focus on the needs of that child and talk about what their hopes were for that child, and that it was best that he was in that potential adoptive mother's home, but the dad still wanted to have some kind of communication. He just wanted to get pictures, school pictures every year, and they were going to make sure he had a list of activities that the son was involved in so he could be part of those school activities and sporting activities that his son was involved in. But he said he would not relinquish his rights, however he wouldn't fight determination, because he said he didn't want it on paper that he gave up his son. And that was very powerful to him to be able to say that, to be able to have that voice and let everybody know that that was his intention. But I just, what we always do in these cases is visit with everybody that will be participating. Our preference is to always visit directly with the family members. When I schedule the facilitations or the meetings, mediations with parents, we have them come in and talk about goals of the meeting. What we understand that Health and Human Services and the courts are looking for, and find out what their perspectives are and what their wishes are for the future in the meeting. And then we gather as much information as possible. We visit with attorneys on the phone, guardian ad litems. We don't schedule you guys to come in because you're awful busy. But any information we can get to help us have as much information as possible to provide the best process and timing. I mean, there's been times we received a case for an FGC and we said, you know what, it's not appropriate for that. It needs to be a mediation or just a couple-hour facilitation. I've gotten a case. We tried to spend quite a bit of time talking to a case manager and supervisor saying the mediation isn't the right process for this case at this time. It really should be a family group conference. And against our better judgment, we went ahead and went with their wishes to schedule mediation. We had all the service providers there, attorneys, grandparents, bio parents, and it was not successful. Everybody left frustrated because it was the wrong process in that case. So, we don't just arbitrarily say, oh, off the top of our head it should be this or that. We really do talk to the clients, get as much information about the case as we can before we determine what process it is. And then there's been some we said, this isn't appropriate for a mediation at this time or an FGC. It's not, the timing isn't right, and so we'll just close the case and won't move forward on scheduling anything. Because we don't want service providers or family members to leave with that bad feeling it was an unsuccessful, unproductive meeting. And even when families don't reach agreement, they often leave the room with just a better understanding of what's going on and what steps need to happen, and just feeling better about themselves that they had a voice and that they were able to be heard and understand. So.
Just a note about safety, because, you have a question?
Is there an objective criteria that you use to determine what case is best for the facilitation or mediation versus what is best in a family group conference setting? Or is it fact-driven?
It's largely fact-driven. If we have, and it's I would say consultative. We have to consult with other people who are doing this kind of work, most often in our own offices, but sometimes we call other family group conference providers across the state and say, this is the set of facts, this is what we're facing, how do we do this the most appropriate way? We have had some caveats about safety, and one of them that I did pull right at the very end was a case where the parents' behaviors were so threatening to the rest of the family and so specific that we had to, in order to protect those family members who were going to come and say what they needed to say for the protection of the children, we had to just pull it because it wasn't the right process. You need a meeting where that can go on the record. You know, we really needed a different kind of non-protective facilitated meeting to happen in that particular case.
Well, generally the situation is you're there and you want to send it somewhere, and you have to make the determination in that setting without bringing everyone back which venue to send it to or to order that the parties participate in. So how does one make that assessment there?
You mean for the court?
Yes.
I think often that it helps very much if the court knows what the different processes are. And sometimes they can say, I think this needs some kind of mediation service. And we've had our judges do that. They've also said, we strongly suggest you do a family group conference. And they've also ordered them in some cases. They've also ordered mediations to happen. There was a particular case that I'm thinking of that would have really benefited from two grandmothers getting to be better on the same page. And that probably should have been court ordered because we had attorneys who didn't want to do it, a mother who was probably never going to come back, and that one didn't happen just because of the ongoing concern by the two parties that they just couldn't get the same.
At the Clive Court Center, when we're reviewing a case to determine what process might be most beneficial to a family, we really look at what the goal of the meeting is. Often, if children are going to be placed with one of the parents soon and they're going to be getting out of the system, often the parents just need a parenting plan, and based on new information and whatever the parents' challenges are. So that would be a mediation. If it's a TPR has been filed and they need to talk about just future contact, you know, if those the adoptive parents, you know, are going to allow some sort of contact for the birth parents after adoption, we would facilitate that conversation, often with attorneys in the room. Sometimes it can just be among the participants, the parents and adoptive parents themselves. The more complex cases, with the complexities of the case, the more family members, the more issues there are that have to be looked at, then that would move more to family group conferencing. If it's just one or two topics that the parties have the power to help make decisions on, that would be facilitation or mediation. But larger, more complex issues where we really do need to have the voice of other family members, and there's a lot of other things that need to be talked about, that would be better suited for a family group conference because that allows for time and everybody to be more involved. And that's a very simple formula.
We have about 5 minutes left, so I know there's a few questions here, so why don't we take questions?
Sure.
Yes.
Facilitated agreements or sessions are also subject to the same confidentiality terms?
Yes. There's a statute that says family group conferencing and other conference hearings associated with child welfare are confidential and privileged, and that's used to
Lack of enforceability of agreements.
enforceability. What happens to the agreement? I heard that question earlier as well. It works out differently in different jurisdictions. There isn't a tried and true way. Some jurisdictions you have a mediated agreement or facilitated agreement, and and that gets entered into the record at court. It gets read into the record. Other places it gets implemented into the child welfare case plan. So it's like a summary of an agreement that then gets incorporated into the case plan itself. Do you remember what Judge Cubbin said yesterday, what she did with hers? When she sends parties to mediate and they come up with an agreement, they come in and they read it into the record. So that's how she handles it. The one thing that I think she was talking about TPR, and this is the one question I have for you, and something that I feel pretty strongly about from a policy perspective, is I don't like the idea of a facilitated TPR scheduled the morning of the TPR hearing, which is in the afternoon. I mean, that is, to me, it's undue influence. It can be reversed later on. Parents, what I heard in my research nationally is that there's not an expectation at a facilitated TPR that there will be a written, that there will be a signed agreement that day. You know, it's that saying you have 3 days to think about it before you sign the dotted line. This is a parent's civil rights. And so my sense in terms of a policy perspective is that if you're doing a facilitated TPR, that it's an opportunity for a dialogue to address some really key questions that we want, as facilitators, we want each of you to be your best at the table. We want the parents' attorneys to be your strongest, say what you need to say. We want the guardians ad litem to lay things on the table. We want the parents to be able to have that voice. And that's our job, is to be able to facilitate those hard conversations that may or may not result in some kind of relinquishment. That's not our goal, to get a relinquishment. But the goal is hopefully to educate and inform, to have all this information on the table about why we are at the relinquishment stage, and then allow people to make some decisions. Maybe they don't make them there at the table, maybe they make them after sleeping on it for a couple of days. But then, as Debra said, sometimes people already have made that decision and we need to facilitate a dialogue for a post-adoption. I have time for one or two other questions. I know there was a couple.
The speaker also said regarding confidentiality that the agreement is read into the record. But if someone tries to speak about what was said in the mediation session, she does not take that into account.
And just to repeat for the tape, the judge said that the agreement is read into the record. However, the content of the dialogue is not allowed to be brought forward in the open court. A lot to think about. Oh, one more question, Nicole.
I just wondered, what did you see as the potential outcomes of a facilitated TPR? Like, I guess I see two basic ones. They relinquish and come up with some sort of agreement they're happy with, or they say, no, we're going to have the TPR trial. Is there other?
Those are the obvious ones,
yeah.
And some of the other around that come along with that is, first of all, for the child, that the experience that the child has with the parents and relatives, or if there is going to be a post-adoption agreement, that the child starting off with hopefully the healthiest relationships between those parties as possible for their future. Also for the child, moving the process forward expeditiously, without coercion. But can you imagine if this does go forward in a relinquishment, the impact it has on the legal process for the child? And another outcome, of course, being working an employee of the courts, the impact on the court system. Timeliness in terms of permanency, that's an outcome that we're all needing to look at. But again, we don't want this, that's why we want the guardians ad litem, the county attorneys, the parents' attorneys, to be the strongest, the best you are in terms of each of these cases. Because I don't want to be a facilitator where it's kind of just a rubber stamp process. It needs to be a robust dialogue about, does this make sense? Yes.
So during the facilitated TPRs, if you're correctly, you don't generally have a representative to stay there, you don't have a county attorney.
It varies from jurisdiction to jurisdiction. I think, Judy, in your jurisdiction, you have the county attorney at the table, and I think, and sometimes you do, however, maybe only for pieces of that. For example, the very beginning of the facilitated dialogue, to have the county attorney put forward the rationale as to why they're going forward.
You know, I think that's important, although at the same time, I think as a deputy county attorney, I would want to be there, but I think if it causes a problem, if it intimidates the parents, the guardian ad litem's interest is, you know, and the state's interest are both the best interest of the child. I think the guardian ad litem probably advocate their state's interest, but I do have to think of something else. Get something resolved here, and obviously the guardian is making a decision in the state in terms of what if the parent wants is unwilling to relinquish a situation where they could have voluntary guardianship.
And there's an exploration of all the permanency options, and I think that's part of the well-being. Sorry, I'm going to have to cut it off. We're done at 10. We'll be able to answer individual questions. I guess we're done at 11. We started at 10. So thank you so much. Really great opportunity. I learned from you as well.